You got it? You can see it?
Yes, this is one of the new laws that goes into effect today that our new governor enacted, I believe, a special session when he first took office to get tough, what he calls being tough on crime. This new law basically, anybody convicted of a crime from August 1st, any crime committed August 1st moving forward, if you're convicted of a crime, now you have to do 85% of that sentence. So let's say you get a 10-year sentence, that means you have to do 85% of it. Probably 8 years, 5 months, somewhere in that area.
5% of all sentences moving forward must be served, right?
Yes, and definitely a big change here in Louisiana. Previously, if you were convicted of a nonviolent offense, you could get what was called good time or parole. And your parole eligibility on non-crimes of violence, generally on your first time, was somewhere in the area of doing 25% of that sentence. Your good time percentage on all nonviolent offenses prior to this new law was somewhere around the area of doing 35%. So that's how you get people accused of crime saying, do I get 2 for 1, 3 for 1? Basically, in Louisiana, there's no more 2 for 1, there's no more 3 for 1. If you do a crime now, you're going to do 85% of that sentence in jail.
Wow. Now, let me ask you, if a person committed a crime on yesterday, July 31st, 2024, or any time prior to that, do they fall under this 85%?
No, so they don't fall under this 85%. It's only for crimes that are committed today, August 1st, moving forward, they fall under this law.
All right, so if anybody has a family member or friend who's in jail right now or even out on bond facing charges, they shouldn't be freaking out thinking they automatically have to do 85% because they fall under the old law. Is that right?
That's right, unless they committed a crime today and ended up in jail. Let's say they committed a crime at 12:01 last night. They SOL, they shot it up. They should have moved it. Should have moved it a couple minutes ahead or something.
Parole is now restricted and eliminated in some cases.
So previously, a person, by merely serving a sentence, at some point they were eligible for parole, a parole release or a good time release. But with this new law of 85%, the governor is taking the position that people that committed crimes were getting participation trophies for being in prison and just simply being released. So now parole is basically limited to certain situations, and you have to follow a certain class of people and a certain class of crimes now in order to get parole. And in fact, in some cases, it's eliminated outright.
So if you commit a crime, don't count on parole because chances are
it's not available. You probably got to do 85. So, like I said, previously, a non-crime of violence, you could have paroled out in some cases after 25% of the sentence. Now you got to do 85% of that sentence in order to get released on parole. And on some crimes, there's no parole at all.
Wow. So I would imagine that the criminal code is about as thick as you could imagine. So if somebody has multiple, depending on the crime, even an experienced criminal defense lawyer as yourself, you got to go look through the book and look at the statute to see when and if that person qualifies for parole.
Yeah. It's going to take some time to make some adjustments. This elimination of parole in good time and also do 85% of sentences, I think it's going to cause a backlog in criminal cases because an inmate previously had an incentive to plead guilty and to accept responsibility for what the crime they were accused of. However, now I think that is pretty much diminished. Really no incentive in some cases to plead guilty if you're going to have to do 85% of the sentence. I definitely disagree with these, but those mere facts. I think that's going to require more jury trial. And I think that's in turn is going to burden the system that's already due to the COVID backlog that we still haven't been able to get through.
So what are they going to do with all these people? I got questions like pretrial detainees, where are they going to house them? Inmates, where are they going to house them? If all these people are serving 85% of their prison term in jail, do we even have enough prisons in Louisiana, or is there going to be yet another boom in the prison system? Are we going to build more jails, more prisons? What are we going to do? Louisiana already has the highest incarceration rate in the world, higher than Russia, higher than China. as far as the percentage of our citizens who are incarcerated. So where are we going to put all these people?
I don't think when they're making those decisions that they envision these problems. So I think I don't know where they're going to house these people at.
Elephants open in the courtroom, great elephant defending the innocent, mind sharper than a tenement, criminal defense, game stronger than cement. Out here wrecking cases so your time may spent. Suits clean as a glass, arguments intense. Great elephant in the zone, watch him commence. Law books tattered but the flow never fed. Trapping legal, heavy on the blocks. Great elephant got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock. Tell the judge to relax, swaying the parole. Jury nodding heads, great elephants control. No sweat under pressure, ice in his soul. Not a cuff, break free, legal as his goal. Late nights grinding, paperwork and stacks. Great elephant beats facts and facts. From the trenches to the marble floors, straight facts. Criminal defense, kingpin, never falling back. Trapping legal, heavy on the blocks. Great elephant got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock.
No more 2-for-1. So you touched on that. What else can you tell us about it?
I just mean now you commit a crime, people, young people especially that have no experience with the criminal justice system, I think you need to ask yourself prior to committing a crime, are you prepared to do 85% of whatever the sentence is of the crime that you're going to commit? It used to be some people would take the position that I got to do 25% of the 10-year sentence, or I got to do a year. But now it's pretty significant sentences that people now face. The good time law is just no longer in existence.
Let's see what else we got. 17-year-olds are now considered adults. Tell us about this.
Under our former governor, there was a law passed that allowed children who are 17 to have their cases, if they committed a criminal act, certain criminal acts are allowed to be stayed in juvenile court, in delinquency court. However, under this new law, if you're 17 years old and you commit a crime, you're going to be in adult court. You're going to be facing the same penalties that an individual that's 37 years old, 27 years old, 47 years old, and above will be facing. So now they're not treating children as children any longer. And I think this is due to the influx of juveniles committing crimes. I believe some people take the position that juveniles know that I'm only facing a juvenile sentence. I'll either get in trouble, go home in a couple of months, couple of years. There's no real consequences here because I'm a juvenile. I think this is in direct response to the explosion of juvenile crimes, where there's carjacking, robberies, juveniles with guns, juveniles shooting people. So I think this is a responsive law. I don't think it's a good response to it. I think we've tried that already with juveniles, and it hasn't worked. Being tough on crime with juveniles hasn't worked. Being tough on crime with adults hasn't worked here in Louisiana. If being tough on crime was to deter people from committing crimes, we wouldn't have the highest incarceration rate. We wouldn't have so many people in jail if these laws actually act as a deterrent. There's a lot of studies out there that say juveniles, specifically males that are under 25, that their brains haven't developed fully. That's why the law was in place to treat juveniles as kids, 17 years old, as kids, and not to treat them as adults, or not to hold them to the same standard that they would hold an adult to that committed the same offense.
It sounds to me like you don't think this is fair.
I don't think it's fair for a number of reasons. I think you have to think about it. Most people, when you're 17, you're probably a senior in high school. You're not aware of what a crime is. Knowledge base, or your point of reference, if you get in trouble, is generally you go to the principal's office. The principal either suspends you or gives you some kind of administrative sanction, whether it's in-school suspension. At the very least, that's your point of reference. But now you're telling 17 years old, let's say, have a prescription for Adderall, which a lot of people do. and he has his Adderall, he takes his Adderall. Let's say he has a friend that says, hey, I want one of your Adderall. Can you give me one of your Adderalls? I don't have any. I'm out of mine. And that 17-year-old passes that Adderall to his friend. He just committed a distribution. He's not aware that's a distribution. He's thinking, my friend needed some medicine. He has a prescription. He asked me for some, and I gave him some. But under the law, the plain reading of the law, that would be a distribution here in Louisiana.
All right, let's move on to the next one. Post-conviction relief is limited. So, first of all, what is post-conviction relief?
So, post-conviction relief is after you've went to trial, after you pled guilty, after your appeals have ran, there's a procedure that allows a person to bring up issues that maybe could not have been brought up at the time of trial, or issues that they later found out. It could be in a version of newly discovered evidence. It could be prosecutorial misconduct. The prosecutor did something, withheld some evidence. The police officers withheld some evidence. The police officer threatened witnesses. Or even in some cases, the defense attorney was not effective. In Louisiana law and also federal law, all defense attorneys that represent people accused of crimes provide effective representation under the Constitution. And what's happening here with this post-conviction relief is limited. Now what the law is saying that previously there's a 2-year window that a person has to file a post-conviction claim. But what we found from the Innocence Project and other agencies that handle a lot of post-conviction is that sometimes a person is in prison, this information may not become aware of them until after that 2-year time period has ran. And in this case, the governor is now saying that in order for someone to just file in the district court, you would serve the district attorney of that parish where you were convicted. You had to serve them with a copy of it. And a judge at that point could either grant you a hearing on your motion, or he could deny it, or he could do various things. In some cases, the prosecutor could look at your post-conviction application and determine that, hey, this has some real merit to it. Maybe his defense lawyer was not effective. His defense lawyer didn't do an investigation. A prosecutor in my office did something that they shouldn't have. But in this case now, post-conviction, they're saying that it's limited because now you also have to serve the Attorney General of Louisiana with your post-conviction application and put them on notice you're filing. So this somewhat eliminates the deal that a local prosecutor could make with a defendant in a lot of cases to give them some form of relief. The post-conviction laws are also limited now, is that it used to be there was a 2-year window. After the 2-year window, there were instances where you could file and bring your claim, but there's also some limitations there now as well to further prohibit or place more burdens. They're saying that once you're convicted, they're trying to keep the people in jail no matter what happens. They don't want to give them an opportunity to find these things to get released.
So it sounds to me like, and you correct me if I'm wrong, but the post-conviction relief application really comes into play to help people who have been failed by the system. Would that be fair to say?
Yeah, failed by the system, whether it's failed by law enforcement, a prosecutor, or a defense attorney doing something wrong in their case. Something illegal happened that shouldn't have happened. We're going to limit it. And also it's limited in previously, once your 2-year window had ran, it was considered time barred. But under this new law, they're saying, and in previous cases, the defendant and the prosecutor agree that this has some merit, so we're going to the limitations of the 2-year window for you in this case. We're not going to do it in every case, but we're going to do it in this particular case because your case has some merit. This new law prohibits those agreements from occurring between the prosecutor and the defendant and his defense attorney on their post-conviction application.
So sounds to me like there are a lot of innocent people in prison. We know that there are a lot of innocent people in prison. But when we talk about those innocent people in prison and their innocence isn't discovered until 3, 5, 10, 15, 20, 30 years later, it sounds like it's going to be harder than it already is when we know.
It will be. The post-conviction process isn't an easy process. It takes a lot of work and it takes a lot of time sometimes to develop that, to find these witnesses. If they don't come forward for years and years. And if you even look at the inmates that are on death row, Louisiana at one point had the most people on death row, but at some point, I think Louisiana also had the most death row exonerees from information coming later showing that a prosecutor did something previously that caused this person to be on death row, and they later found evidence that showed this person either didn't commit the crime or the person did commit the crime that they were accused of, and that gave them some kind of relief and got them off of death row. But this new law is probably going to keep more people in prison, more people on death row than we previously had.
So this needs to be remedied ASAP. Probably won't happen in the next 4 years with this governor, but something needs to be done about this. So let's see what else people need to be concerned about. All right, concealed weapons are permitted without a permit. So I don't have to go out and get my concealed weapon permit? That's what you're telling me?
Yeah, so this new law says that a person who's not breaking the law, a law-abiding citizen now can lawfully carry a concealed weapon without a permit. The issue becomes that even if you have a concealed weapon permit, you can't get intoxicated, right? So if you're carrying a concealed weapon without a permit, or with a permit, I believe you expose yourself to potential criminal consequences by merely being intoxicated and carrying a concealed weapon. I think there's going to be some issues there. Also, if somebody has a little bit of marijuana with them, I don't think this law that they enacted can account several other laws. Additionally, now you have to be aware that a person who commits road rage, or you're at a store, somebody could be packing a gun, so you simply pushing your buggy down the aisle, and maybe you back the car into somebody's foot, they may be packing, and they may get angry and pull their gun out on you because they're upset that you simply ran over the back of their foot with a basket in a store. I think this law, this is a very scary law. You don't know who has a gun now, and I think the benefit of having to require a permit for a concealed weapon was that you had to take some kind of firearm training. You had to take a class that was 8 hours that taught you how to shoot, how to safely disarm a gun, how to break a gun down, how to clean it. So now this new law is taking that requirement away, and I think it presents some scary alternatives to now what we're going to have here in Louisiana. Basically, we're pretty much going to be the Wild West.
Let me ask you a question. A little bit of marijuana is a citation. Then there's a small amount under how many grams is a misdemeanor?
Under 14 grams.
All right, so Tim has 13 grams of marijuana and a firearm. He's carrying a concealed weapon in one pocket, and he has 13 grams of marijuana in the other pocket. Misdemeanor marijuana and a firearm. Is that a problem? Are there any laws that make you pause?
I think it should make you pause because I think it's still a legal carrying of a firearm because you have a legal firearm. And I think based on your hypothetical, we're assuming that Tim legally owns his gun. Whether he bought it himself, someone gave it to him, it's not stolen. He's not a convicted felon. He doesn't have an active restraining order or a previous restraining order. Tim is legally carrying a gun. He's lawfully carrying a gun. In Tim's case, if he had the 13 grams of marijuana, I believe that law wasn't changed, so he's potentially facing a misdemeanor, what's called illegal carrying, because he has under 14 grams of marijuana and he has a firearm. Some people would argue my gun is legal marijuana, unless Tim has a prescription. I don't even know if the law even took that into account. That if I have a marijuana prescription and I have my gun, am I still breaking the law? So I don't think this law envisioned that potential issue, but I think it becomes an issue that someone could get arrested and not be convicted of it. But I don't know if there's any guidance that's been given to law enforcement to say if somebody has a concealed weapon now and they have some marijuana, you can verify whether or not that marijuana, because we know the concealed weapon is legal. And now we also know that people in Louisiana can get a recommendation for medical marijuana. And if this person has that, I don't know if that law took that into account. And so I think there could be some potential issues there.
So let's say a scenario a little different. Tim is lawfully carrying his firearm and he has more than 14 grams of marijuana, but he does not have a prescription.
Yeah, I think Tim is facing a potential felony charge. The drug dealer, let's say Tim has one lower tab, doesn't have a prescription for it. I believe Tim could potentially be prosecuted for illegal carrying of a weapon with a CDS, a controlled dangerous substance.
If we look in the criminal code, there's a specific statute that a felony is illegal possession of a firearm in the presence of a CDS.
It's legal carrying of a firearm in the presence of a CDS. And the firearm could be bought from any gun store, but if you have some illegal drugs, whether it's cocaine, marijuana, or more than a certain amount of marijuana, different prescription pills that you don't have a prescription for, that makes a gun illegal. And previously, even if you had a concealed weapon permit, you couldn't be under the influence of alcohol or drugs that made you intoxicated. So I'm not sure if these newly enacted laws took into account all those different variables. So it'll be interesting to see how someone gets arrested, how this will be prosecuted.
It sounds to me like a setup almost. It's like there's going to be a lot of people who have no intent to commit any crimes, who don't have a criminal record, and they're taking two conceivably lawful things, combining them, and now they're facing a potential felony offense. It's almost as if the legislature just had this knee-jerk reaction where they passed this law without looking at the other laws that work in conjunction with it.
Yeah, I think that happens a lot, that you have some people, legislators, making these laws that don't actually practice in criminal defense work. They don't understand that there's checks and balances and there's building blocks that you have to take into account different variables. I don't think those variables were taken into account. I think it'll be interesting to see how this all plays out. I believe in firearms, but I believe in possessing firearms legally, correctly, and safely. And I don't believe this new law takes into account that you're going to have a lot of inexperienced, emotionally unavailable individuals that can't control their emotions possessing a firearm now that could easily be set off by merely, as I said, the example I gave earlier, merely being at a shopping center and somebody doing something to them that they deem disrespectful or they deem that has escalated beyond a mere argument. This is a very scary law that now you have to be real cautious of who you talk to in the store or in your surroundings, because now people just get in an argument and pull guns out now because they can legally carry a concealed weapon. And I'm real concerned about it. And I'm a card carrying member. I've been having my concealed weapon permit card probably for the last 3 years. Even with that, I rarely take my gun out of where I keep it at. I just don't feel the need for it, although I have a concealed weapon permit. I think, to me, that's very scary.
All right, let's talk about this. You cannot come within 25 feet of a police officer conducting an investigation or working. What's this about?
So I truly believe this is some sort of a compromise. I think the initial bill that was proposed was that they wanted to pass a law that said you could not record police officers. Imagine that in the United States of America, that they were trying to pass a law that said you could not lawfully record police officers who were conducting a lawful arrest or a police investigation. This definitely goes against everything we saw for the last 4 years with the George Floyds of the world, with the Michael Browns, and all these other cases where, had it not been for somebody recording, some citizen recording the police illegal act, these individuals would have never been held accountable for their actions. So the compromise here was that they came up with this rule that said you can't go within 25 feet of a police officer's conducting an investigation or working, which I think, to me, that's going to be another issue, one of those issues of how do we determine what does working mean, what does the investigation mean, and what happens if a person sees a police officer doing something wrong, and who determines the 25 feet? Because we have to remember that all police officers don't have body cam, right? So who's going to determine, who's going to mark off the 25 feet for the police officers to say, hey, you can't come in this restricted area. This is a restricted area. So I think this was, in my mind, to some law probably proposed by law enforcement that means if you're in law enforcement, you shouldn't have a problem with being recorded by citizens if you're doing your job properly. But I think this is going to be a problematic law because it's going to be hard to determine what's the 25 feet and determination of it. How does a citizen know knowingly violate this law if I just see a police officer outside? How do I know he's working? Is working mean he's just on the clock? Does working mean he's actually involved in an investigation, actively arresting someone? What does an investigation mean? So all these words, I think, is going to present an issue that somebody's going to have to define what that means at some point. Some appellate court is going to have to determine, or the Louisiana Supreme Court is going to have to determine what does this law mean and how do we determine the 25 feet.
And if I'm trying to picture 25 feet in my head, and I know there's 3 feet in a yard, so a first down in football is 10 yards, which is 30 feet. So we got to be somewhere less than that. Sounds like we got to be about 8 yards away, 2 yards from a first down in football. Now, if you're not familiar with football, and even if you are, I think in a real life scenario, that's going to be hard to determine.
I think someone can find themselves being arrested merely for trying to video the police officers and getting within that, because we don't know who determines that 25. What is that 25 based on? Is it from all officers, or is the officer actually conducting an arrest and investigation, or if he has backup out there and they're 10 feet away from him?
You have to be 10 feet away from the officer who's 10 feet away from the incident.
So
10 feet away from the officer setting up the perimeter. What do we do? Zoom in with our phones, take pictures or videos?
I think it's going to be one of those laws that are going to be a matter of interpretation. Somebody's going to have to come in and interpret it, because I think it's one of those laws that wasn't well thought out, and it's another reactive law, I believe, to shield law enforcement from further scrutiny that we saw here, even with the Alton Sterling here in Louisiana situation. We had somebody videotaping it and saw the cops murder Alton Sterling. And in that case, that individual, from what I can tell on that camera, was pretty close. That individual would have been breaking the law by being that close to videoing it based on this new law that was enacted.
Wow. Let's see what else is going on in the great state of Louisiana. Police can now arrest a driver of a motor vehicle who
refuses to provide his identity. This is a law that requires now, there was some instances where a person, you could refuse to identify yourself to law enforcement. But now this is saying that if you're a private citizen driving a motor vehicle, you now have to identify yourself. And if you refuse, law enforcement has the discretion to arrest you for failing to properly identify yourself and to allow law enforcement to identify who you are.
All right, and I think we got one more to talk about. Selling fake prescription pills laced with fentanyl is now punishable by 10 to 40 years, 10 being the minimum, 40 being the max.
So what in this current fentanyl epidemic, what a lot of savvy drug dealers have been doing is that nobody wants to openly just buy fentanyl, right? Nobody's just saying, hey, I want some fentanyl, because the danger of it is very dangerous. So what some savvy drug dealers have been doing is that they purchase pill presses, whether it's on Amazon from other countries or just locally. They purchase pill presses, and what they've been doing is pressing pills to falsely identify as, let's say, a Loratab or a Xanax bar. And what they were doing is putting the actual drug in that pill. They're lacing it with fentanyl to give the person some form of a high. And the person unknowingly is ingesting fentanyl, thinking, maybe I bought this Loratab off the street from some guy that said he had Loratabs for cheap. Maybe I bought the Xanax bar from someone that told me they had Xanax bars for cheap. This pill is now laced with fentanyl and potentially could kill you. And so this particular law, I think, is another responsive law. I think we have enough laws in the book that punish fentanyl. I can agree that fentanyl is a very dangerous drug, and it has caused a lot of deaths of recent. But this is one of those laws now that if you're selling fake prescription pills, basically selling a counterfeit pill laced with fentanyl, you're facing up to 40 years in prison with a mandatory minimum of 10 years, which the judge and the prosecutor, you have to at least get 10 years.
I do criminal defense as well as you, but this is one that's on the books. I can't complain about it. I think we've gone through 9 different laws, and this is the one I actually do not disagree with. People are dropping like flies. There's all this fentanyl coming in from China, and nothing is being done to stop it. And I think they're just trying to save some of our citizens. If somebody's gonna buy a drug, it'd be nice if they were getting what they thought they were buying. Not that I'm in favor of people taking illegal prescription drugs that they don't have a script for. If somebody thinks they're taking Loratab or oxycodone and they're taking fentanyl, that's a problem. Hospitals struggle to properly administer fentanyl. There's a lot of medical malpractice cases that occur because the doctors in the hospital with Narcan on the crash cart administer too much fentanyl to people. Of the 9, I'd say the legislature is 1 for 9. I would agree with this one. I have issues with all of the others I've seen. Hopefully we can flush them out and clean them up and clear them up over the next few years, because we have to do what's best for our citizens, and a lot of these laws are borderline barbaric, except for this one.
I think there's no complaint. It's hard to complain against this law. We also have to remember that if you sell it, but there's another penalty if you sell somebody a pill that's laced with fentanyl and they end up overdosing and dying. You're facing a life sentence on a second-degree murder case, because that's considered murder here in Louisiana, dispensing some narcotic that causes someone's death. And in this case, so this is just for selling it. And there's a whole other penalty if you actually distribute it and that person dies as a result of you distributing that drug.
All right, great. I want to thank Harry for coming on, even interfering with his fatherly duties to come on and join us and talk to us about some of the current laws that are taking effect August 1st, today. Once again, if you found this content useful, please the video, go to YouTube, subscribe to Great Elephant Law. You can follow our law firm, Daniels in Washington. We're on Facebook, Instagram, YouTube, TikTok. We also have our personal profiles. Mine is Great Elephant Law on Instagram, and just my name, Christopher Washington, on Facebook. How about you, Harry? What's your name on Instagram if they want to find you?
My Instagram name is Attorney Number 1. So they can find me there on Instagram, and if they're on Facebook, they can follow me at Harry Daniels III on Facebook, and also Champions for Justice on Instagram as well.
If y'all have any questions for us, feel free to leave a comment under the video or go find us on social media and DM us. We will try to continue this, hopefully on a weekly basis. That's the goal, but we do have a lot of trials. We try a lot of cases to juries. We have a lot of hearings in our criminal and civil matters, civil being personal injury. If you need our legal advice or legal representation in any of those areas, don't hesitate to reach out. Have a good evening and peace. Anything you want to add, Harry? Nope, I guess not. He's off. All right, take care, folks.
Great elephant in the court, stomping ground, defending the innocent, justice profound.